The topic of my presentation today, you can see on the first slide, and it's quite a challenge in the way to present the range of jurisprudence of the Strasbourg Court on asylum matters within 45 minutes. So already in the agenda, it's mentioned that I will focus on so-called pushbacks, border-related issues, so to say. But however, as the topic is broader, I have decided for the following presentation you will expect in the next 45 minutes. First, I will give a short introduction to the topic, and then it will follow a more general overview on cases on asylum matters very briefly, just for comprehensiveness reasons. And then I will turn to the so-called pushbacks, the returns at the border or shortly after entry into the state territory. I also listed some points, potential points for discussion, if you like to join on these topics or present any other question, topic, remarks. It will be very welcome. So, the topic, it's the recent jurisprudence on issues related to asylum and returns decision. And in terms of recentness, I decided to focus on decisions from last year and this year. As I said, the more general ones for the general overview, and specifically on so-called pushbacks or hot returns. I will come back to this terminology later. The general overview will be more or less in a chronological order. And then the case law on border returns will be focused on of course, the relevant provisions, which I have listed here, you can see. But I also divided between the different settings at the border, the different situations people on the move face when they enter and approach the borders, because as we will see, the settings are different. Yeah, maybe I go back and for the terminology. I will insert it here. I wrote here pushbacks or so-called hot returns. Interestingly, there is no internationally agreed definition of the term pushback in the area of migration. So I listed here a quote from UNHCR, how it defines these measures as various measures taken by states which result in migrants, including asylum seekers, being summarily forced back to the country from where they attempted to cross or have crossed an international border without access to international protection or asylum procedures, or denied of any individual assessment on their protection needs, which may lead to a violation of the principle of non-refoulement. So as you can see from this definition, it displays also the main provisions which are concerned. So Article 3, degrading treatment, prohibition of torture. Article 2, right to life, ineffective investigations, we will see later. And a provision that in at least the judicial practice is not very present. It's the prohibition of collective expulsion enshrined in Article 4 of Protocol 4 of the Convention. So now for the first case, Akkad versus Turkey. It's a judgment of July of last year. It's the expulsion of a Syrian national by Turkey after a failed attempt entry into Greece. Obviously, the person stayed in Turkey, Mr. Akkad, for 2 days, and stayed in Greece. So And the court established a violation of Article 3 because of the immediate expulsion of the applicant who had a provisional protection in Turkey, so a kind of protection status, but not a full refugee protection status. He was facing a real risk of a treatment by the national authorities in the country of origin, which violates Article 3, a degrading treatment during the transfer from Turkey to Syria because the person was handcuffed during this transport. And in this, the court saw also a violation of Article 3. And there was a violation of Article 13 in conjunction with Article 3 because there was no effective remedy to challenge the removal from Turkey, the one point, and on the other point, the deprivation of liberty due to the arrest. Also, there was no effective remedy to challenge this. Another important case was decided in July 2022, and it concerned the sinking of a refugee boat in the Aegean Sea after a rescue attempt by Greek Coast Guard. So here, the court also established a violation of Article 3 because of the, my slide has disappeared, violation of Article 3 because of physical inspection of the applicant in presence of other migrants. So this was the issue. So he was inspected, he had to put off his clothes in front of other migrants, and so there was a violation of Article 3 in this, and a degrading treatment because of the extreme vulnerability in such situations for the applicants in general, but also in the case concerned. Further on, the court established a violation of Article 2 because of the death of relatives of the applicant. So it was both a violation, a substantive violation of the provision, and a procedural one because the procedural guarantees were not provided insofar by the Greek authorities because there was no effective investigation of the incident of the death of the relatives. So the court submitted this under Article 2. In the same line, and that's why I've mentioned it, it's an older case, it's from November 2021, MH and others versus Croatia, also an important case. The case was on a family with 14 members and the death of a young child because of a train accident in Serbia after a forced return from Croatia. So the situation that people were sent back from Croatia, they had to walk, and they walked on a railway track, and there the child, one child of the family, came to death. So here the court saw a violation of Article 2 in its procedural sense because of the, again, a lacking of an effective investigation of the death of the child, and a violation of Article 3 substantial because of keeping the child for 2.5 months in reception center, the other children, of course, not the one which died, but the other children, keeping them for 2.5 months in the reception center in Tovarnik under prison conditions, established for the children, but not for the parents. And in addition, a violation of Article 4, Protocol 4 of the Convention because of a summary return of parents and the 6 children by Croatian police outside official border crossing without prior notification of Serbian authorities. So this is also in the same line, interestingly, how the death of relatives is regarded and submitted under the relevant provisions by the court. The next case is BY versus Greece from January of this year, and it concerned a forced removal of an applicant from Greece to Turkey after a failed attempt to enter Greece. In this case, again, a violation of Article 3 of the Convention in its procedural perspective, because of the violation of the obligation to conduct an effective investigation of the alleged abduction by Greece police. Also, there were clear indications that the surrender to the Turkish authorities by the Greek officials was conducted by the Greek police. Interestingly, in this case that there was no violation of Article 3 in its substantive limb, because the applicant did not provide concrete or corroborative evidence as to his presence in Greece that would shift the burden of proof to the government. This is a tool the court uses frequently. What is the burden of proof? And in general to say, first it's on the applicant to give substantial hints and evidence, and then the court sees a change of burden of proof to the government. So if you have such evidence, then the government is in charge of arguing against this evidence-based. I found the point interesting in this case because on the one hand, as you can see, it was clear that the person was transferred by Greek officers. So obviously they seemed to act on Greek territory, at least, to start the measure. But on the other hand, the court said it's not evidence-based, the presence in Greece, that he, however, was in Greece. So to my point of view, this is not clear, the point in this decision. The next case, Dabo and Camara versus Italy from July 2022. Here there is a, there is a violation of Article 8, the positive obligations, private life, failure to act with reasonable diligence in respect of declared unaccompanied minor asylum seekers not benefiting from minimum procedure guarantees in age assessment procedure. So the case was a minor and or supposed to be a minor at his arrival, and there were doubts, and so he went under an age assessment procedure. But however, this age assessment must be seen in the light that of the vulnerability of the applicant, of the minor person. So there is a positive obligation how to conduct such age assessment, and this was not provided by Italy in this case. So including procedural safeguards for guaranteeing rights deriving from a person's minor status. This was not obeyed by Greece, so there was a violation of Article 8. There was also a violation established of Article 3 in its substantive dimension, because of an inhuman and degrading treatment, the placement of the minor in an adult reception center in inadequate conditions for more than 4 months and subject to age assessment procedures, breaching Article 8. Interestingly, the combination, a violation established of Article 3 because of a violation of Article 8 included. And in addition, a violation of Article 13 in conjunction with Article 3, because again, there were no effective remedies against these measures. Some more cases for the general overview. WO and others versus Hungary from August last year. Violation of Article 3 and Article 5 because of the confinement of minor children as part of a family, so not unaccompanied, but minor children at the Röske camp at the border, at the Hungarian-Serbian border. We will come back to this later in more detail. And they were confined there for 7 months, the children. Again, only with regard to the children and not for the adults. The next case is R versus France, a judgment of also August last year. violation of Article 3 with regard to non-refoulement. Because of the deportation of the applicant, it was supposed to be a Chechen Islamist to be deported to Russia due to conviction for the preparation of terrorist crimes in Russia, without consideration of the danger for persecution resulting from this conviction. So here the Strasbourg court saw a lack of consideration of this danger. And another case against France, the next one also from the same day, also again violation of Article 3, non-refoulement, because of the deportation again of a Chechen to Russia due to his participation in radical Islamic activities on which Russian authorities were informed in the course of the deportation procedure. So obviously the French authorities informed Russia about the activities of the applicant, and so of course there was a danger for persecution on this. The next case, a Chinese national, Liu versus Poland from August last year. Just to mention for reasons of comprehensiveness, a violation of Article 3 because of an extradition to China, torture, danger of torture, and ill treatment. And the next case, it's also an important case, I think, with regard to expulsion, judgment of December last year, violation of Article 13 in conjunction with Article 3, and of Articles 3 because of the expulsion by refusal of applicant's asylum request without an assessment of his claim as to the risk faced on his return to Bangladesh, giving his reporting as a journalist of electoral irregularities in 2018 in the general elections in Bangladesh. And there was a lacking in the domestic asylum procedures, the lack of access to an effective remedy, and removal without a fresh assessment of applicant's claim established in this case. The next case, Al-Hubayes versus Hungary, February this year. It concerned the obligation of the border police, the authorities, to protect the life of a migrant sinking in a border river between Serbia and Hungary. So they were in a group, and he was together with his brother, actually, and the brother died while crossing the river at the border. And the obligations are mentioned here as seen in the preparedness for rescue activities and for preventive measures in such situation when the state authorities can expect that something like this will happen at this place because of the geographical conditions in this place. So the state has to take care and be prepared for rescue actions, and this was not the case. So the court established a violation of Article 2 and 3 in the procedural perspective by, again, not conducting effective investigations of the incident. And the court saw a violation of Article 2 in the substantive sense by not undertaking all necessary measures to protect the life of the sinking migrant. So this refers to this obligation as a precondition for this judgment. Obligation to care for rescue. The next case, JA and others versus Italy, March this year. The case is about a Tunisian sea migrant who went on the sea path, the Mediterranean Sea, and he was detained in a hotspot center on Lampedusa for 10 days in poor material conditions. Here, in this, the court saw a violation of Article 3 because of an inhuman and degrading treatment, and a violation of Article 5, paragraph 1, a violation of Article 2 and 4, arbitrary deprivation of liberty to prevent unauthorized entry into the country. There was a detention without clear and accessible legal basis, and in the absence of reasoned decisions, applicants were not informed on legal reasons of the detention and the inability to challenge the lawfulness of de facto detention owing to lack of sufficient information. So obviously this person was just arrested, deprived of his liberty without any information on the reasons, things like this. And so to the view of the court, this established a violation of Article 5. And in addition, a violation of Article 4, Protocol 4, prohibition of collective expulsion. It was seen in the removal to Tunisia without proper regard to applicants' individual situation when assessing refusal of entry and removal order. When mentioning Article 4, Protocol 4, I'm not aware, I don't know if you are aware of the scope of this provision. Let me make a little excursus on this, on that point, so that we all know what it is about. We will see later. It's always the question in how far specific measures violate Article 3, or solely, beside, or in addition a violation of the provision of prohibition of collective expulsion. So what it is about, Article 4, Protocol 4 is mainly, I would say, a procedural right, the right of the person, of the applicant, that his or her application is assessed individually. That's the main content of this provision. So it's more or less, I would call it a procedural right. A right to a proper procedure in assessing the application, while Article 3 goes far beyond. So the threshold of Article 3 is much higher, leading to a violation of the non-refoulement principle or an inhuman or a degrading treatment. So this is just a short clarification on this point. What's the relation between the provisions? And I will now jump on the next case. It's A&A versus Sweden from July this year. It concerns the expulsion to Libya after refusal of an asylum claim of an applicant. Here the court saw no violation of Article 2 and 3 because the security situation in Libya is not such that there was a general need for international protection, and the domestic authorities' assessment was thorough and based on rational grounds. Applicant failed to substantiate a risk of being killed or subject to ill treatment on return. Just a remark, when I do training for judges in the application of the convention, I always tell them that you have to be, if you want to be prepared for a challenge before the Strasbourg court, that you have to be very precise and you have to show the court that you have assessed all relevant aspects. And it mirrors in a way, or I tell them that you should mirror a decision of the Strasbourg court against your decision. And we all know they are very long, the decisions of the Strasbourg court. Why? Because they want to see, that's their approach, that all relevant aspects have been taken into account. Not necessarily how it was decided, but at least that they were taken into account with the necessary weight, it has to be seen. And if you issue a judgment like this, mirroring this, then it's most likely that it will be approved by Strasbourg. And this is a good example for this, in this case. And the next case, M&A versus Italy, judgment from August this year, very recently. Violation of Article 3 in its substantive perspective by an inhuman treatment, there's missing something on my slide, treatment by placement of an unaccompanied minor asylum seeker who was allegedly a victim of a sexual abuse. It was a female applicant, a young one, and there were allegations of sexual abuse. And she was kept for almost 8 months in an adult reception center, which was not equipped to provide her with appropriate psychological assistance, which was obviously needed in this situation for the person. And here the court saw the violation of Article 3. So this was the first part of my presentation, and now I come to the second part, the focus on so-called border returns, pushbacks, hot returns. And here I will give a short introduction before we turn to the relevant recent cases, the case law. And we also will see that there are different situations at the borders when people on the move approach the borders. We have sea borders, like in the Mediterranean and the Aegean Sea, Italy, Greece, Spain. We find land borders with different shapes. Some of them are protected by armored fences, barbed wire. We will have a look on this later, for example, in the Spanish enclaves Melilla and Ceuta. But we find this also in Poland and Hungary to some extent. And we have transit zones for applicants, for refugees. For example, at the Hungarian border to Serbia. And we have open borders or green borders where there are no installations on the borderline. So we are facing different border situations. And in general, to mention the efforts of the European states to close and externalize borders have resulted in the widespread use of pushbacks. So we can see that all these measures, installations that were made and increased in the past years were made to, of course, keep people off the territory, but also when they are in or right at the border of the territory, to push them back and send them back. And this handling of migrants, and especially when it is irregular, and what is irregular will be assessed by the jurisprudence. But however, this implicates what we have seen, Articles 2, 3 of the Convention and Article 4 of Protocol 4 to the Convention. In general, one can say the earlier jurisprudence enforced the prohibition of collective expulsion. But there has been a change. And I would say the shift in this is, in the expulsion jurisprudence, starts with the case ND and NT versus Spain, a Grand Chamber judgment from February 2022, where the court introduced an exception of the so-called own culpable conduct. Later on, it's called cogent reasons. I will display in detail later, of the migrants. And while in the previous jurisprudence it was more generally assessed, here the court started to turn to look very detailed on the different border situations which I described previously. So the different settings and how much implicates this on the assessment, on the legal assessment. And I think this is a starting point. This exception of culpable conduct, it's mainly an exception from Article 4 for violation, exception from a violation of Article 4, Protocol 4 protection, and it applies where a person crosses a land border in an unauthorized manner, deliberately take advantage of their large numbers, and the use of force by mere appearance of a large number of persons approaching the border in installation, a checkpoint. And this creates a clearly disruptive situation which is difficult to control, and this endangers the public safety. That's how it is described by the court. And also the court determines whether the state provided genuine access to means of legal entry. For example, border procedures. And if so, if there exist such legal ways of crossing the border, the court asks the question whether there were cogent reasons on the applicant's side not to use these means. So we can see the way how the court assesses very much depends on the concrete situation at the specific border. Are there any means for legal entry? If so, why the applicant did not use it? Because the court only looks at cases where the person did not use it, otherwise it's a matter of course. With this shift in the jurisprudence of the court, I would like to come back to a remark that Professor Goldner-Lang made yesterday. And if I remember correctly, she said that the Strasbourg court legalizes pushbacks in a way. I would not go so far, because you have to see, you have to read the decisions carefully, and if you do this, you can see that the court only established, on first sight, that in some individual cases, in specific settings, it does not violate the relevant provisions of the convention, the measures that were taken against the person concerned. So the court assesses only against Article 3, Article 2, and Article 4, Protocol 4. And this does not mean to legalize pushbacks. Just wanted to make this remark yesterday, but I think I saved it for today. So let's turn to the cases which I have selected. We will start with the Polish situation, A and B and A and I versus Poland from June last year. And it concerned the collective expulsion of Chechen families because of denial of entry into Poland at the Polish-Belarusian border. So here we have the land border situation in Poland. Poland started to erect fences and installations, border installations, but there are also large parts with a so-called green border where there are no installations. And Poland has established specific border stations which applicants are supposed to approach when they enter the border. That's the concept, the Polish concept, the Polish policy on this. And so the question is, what happens if the people don't use the legal ways of entry at these specific border stations? And here it was obviously a case where the applicants pretended to have made an asylum application. And we will see this later in cases. This is always also a very important point in the court's jurisprudence. The way how such an application is presented and the burden of proof for this. Who has to give proof that an application was made? And in which way? For example, if the application is rejected, is not received, not accepted by the officials, how can the applicant prove that he or she submitted such application? In which way? With which content? But we will come back to this later. Here in these cases, the court saw a violation of Article 3 because of the failure to initiate proceedings for the review of the applicant's asylum application. And there was the serious risk of chain refoulement from Belarus to Russia. A violation of Article 4, Protocol 4 was established because of the decisions refusing entry into Poland, and without taking into account the individual situations of the applicants, and were part of a wider policy of not receiving applications for international protection from persons presenting themselves at the Polish-Belarusian border and then consequently returning them to Belarus. And a violation of Article 13, procedure in conjunction with Article 4 and Article 3 and Article 4, Protocol 4, since the appeal against the refusal of entry did not have an automatic suspensive effect and hence could not be considered as an effective remedy. Interestingly, this aspect of automatic suspensive effect, which relates, of course, in the case of Poland to the provisions of the CS and the requirements established there in how far there have to be a suspensive effect. But however, the court took this into consideration. When talking about the Polish situation, before we come to the next Polish case, I have to mention the landmark case of MK and others versus Poland, an older judgment from July 2020, to which the court is referring to also in this case, because here the court established the basis on how to evaluate and to exercise jurisdiction in border procedures, in border situations in general. And what I have mentioned before, the evaluation of evidence, for example, this prima facie evidence, the evidence for submitting an application for protection. And the question when it shifts, the border of proof shifts to the authorities, and it also included the application of the NND and NNT exception, the so-called culpable conduct. So the question, are there official means for entry, official ways, legal ways for entry or not, and if so, why they were not used? The next Polish case from October last year, TZ and others versus Poland, a violation of Article 3, Article 4, Protocol 4, and Article 13 of the Convention in conjunction with Article 3, because of the refusal of the authorities to examine the applicant's request for international protection, the denial of entry into Poland and return to Belarus with the risk of chain refoulement to Chechnya. So we can see the cases all concern more or less the same situation. Russian nationals come through Belarus, approaching the border, the Polish border, and they originally from Chechnya, so there is this allegation of influx of Muslim refugees, which to the point of view of Poland establish a danger for public security. So this is the way how Poland approaches these procedures, and as we can see from the mentioned cases, how the court addresses this. We leave Poland and go to Hungary. So I have some more Hungarian cases. The next one is HK versus Hungary from September last year. And here I describe the facts of the case a little bit more in detail, because it very well describes the situation at the Serbian-Hungarian border, which I have mentioned before. So in the case, after crossing several countries, the applicant, an Iran national, arrived at the Serbian-Hungarian border in May or June 2016, where he was waiting for the admission to the Hungarian transit zone, being registered on a waiting list by an Afghan man. And the applicant tried to enter Hungary several times illegally, but was removed back. So the situation at the Serbian-Hungarian border is the following. There are these transit zones where people on the move are supposed to approach the border and to submit their application. However, to enter this zone, so there seems to be often a crowd, people waiting to enter the zone. There is only a daily quota of people who can enter this zone. And there's obviously an unofficial organization of this situation there by people, private people, other applicants, refugees, sorting out who will be the next to get in by setting up some lists where you can register to enter this zone. So this is the situation at the Serbian-Hungarian border with the transit zones. And here our applicant made several attempts to cross the border, was removed back, but during one such attempt, on the 3rd of September 2016, he was stopped together with another Iranian national in Hungary, on the Hungarian territory, by the border police, and was taken to a minibus with two other individuals waiting in the police station. And the applicant allegedly expressed that he wanted to be a refugee in Hungary, but he received no information or documents and was driven back to the border fence in the minibus, where he and the other individuals in the group were then forced to walk through a gate in the border fence in the direction of Serbia. According to official statistics, 76 individuals were removed from Hungary in that way on that date, the 3rd September 2016. And now, interestingly, after treatment in a hospital in Serbia, following the injuries he's obviously had during these measures, he was allowed to enter the transit zone on 26 September 2016. There he applied for asylum. He was transferred to the inner territory of Hungary into a reception center. And before the negative decision of the Hungarian authorities by 16 November 2017, he left for Germany, where he currently resides. So the case is, he made several attempts to enter, was removed back. Then he tried to manage to get into the transit zone. Finally, he made it. But on one attempt before he entered the transit zone, this is the point where the court is referring to. This must be very much clear from the facts. So finally he managed to go there. But The court only looks on the 3rd of September 2016. And here's the decision. It's a judgment of the 22nd September 2022. The court established a violation of Article 4, Protocol 4, and Article 13 in conjunction with Article 4, Protocol 4. Amongst other things, the court established that the measures amounted to an expulsion. So the court assessed against Article 4, Protocol 4, collective expulsion, and he first established that it has been an expulsion. Why? Of course, it's rather obvious, isn't it? This is due to the fact that a lot of governments argue that under their national legislation, such measures are not seen as expulsion. It's a reaction on illegal behavior, an entry without permission, something like this. So they do not say it's an expulsion. We do not expel the people. We just reject them, or however they call it in the national jurisprudence. And that's why the court says, however it's called, it is an expulsion. That's why I mentioned this here. And regarding the collectiveness, the collective nature of the expulsion, the case is similar to Chassat. I have to mention this case, or the court is referring to this case because it's also on the Hungarian situation. It was in the same setting. But in Chassat, the applicant did not manage to get into the transit zone. Here in our case, the applicant managed to do so. So the court describes the general situation in the Chassat versus Hungary, jurisprudence, where the court found that the removal based on the same national Hungarian provisions violated Article 4, Protocol 4, because it had been carried out in the absence of any decision and examination of the applicant's situation. The only means of legal entry at the two transit zones, means of legal entry, ND and T jurisprudence exception, legal entry at the two transit zones could not have been considered to be effective in the view of the limited access, the daily quota, only a short number of people can enter the zone, and the lack of any informal procedure accompanied by appropriate safeguards governing the admission of individual migrants. The applicants first had to register on the informal waiting list and then potentially had to wait for several months to be allowed the entry into Hungary. So this is Chassat. But now the case is different. Here the applicant managed to get in. So unlike Chassat, the applicant in fact had been put on the waiting list. And after a few months of waiting in Serbia and a few failed attempts to Hungary, irregularly, he was admitted to the transit zone and he could apply for asylum. However, on the 3rd of September 2016, he had no information as to whether or when he would be able to gain access to the asylum procedure. The mere fact that he later managed to enter the transit zone could not make his removal from Hungary on this specific day compliant with the convention. So I think this is an interesting case. It's a very limited view the court takes in this case, to my point of view. Okay, looking on the clock, I will move to the next cases. December last year, 2022, WA and others versus Hungary, a reference to the famous Ilyas and Hamid case versus Hungary. This has been mentioned yesterday. And here in the current case, the court saw a violation of Article 3 in its procedural limb in not having assessed the risk of the applicant's summary removal from Serbia for expelling them to a country. The general presumption, and this is the interesting point in this decision I see, would say the general legislative presumption that Serbia was a safe third country, so this was assumption by Hungary, had not been sufficiently substantiated. The authorities' individual assessment of the Serbian asylum system did not take into account the findings of the UNHCR, according to which, at the relevant time, asylum seekers returned to Serbia ran a real risk of not being protected against refoulement to North Macedonia and then further on to Greece. The Hungarian authorities had exacerbated the risk faced by the applicants by inducing them to enter Serbia illegally instead of making an agreement with the Serbian authorities concerning the readmission. So in all this, the court saw a violation of Article 3. Not only Article 4, Protocol 4, but the highest threshold of Article 3. And then finally, a judgment of May this year, RNN versus Hungary, again here, but here only, so to say, a violation of Article 4, Protocol 4, because of the removal of a minor Pakistan national to Serbia after his illegal entry without a chance to claim for asylum. So this was the pure procedural rights perspective, I would say. Okay, moving on from Hungary. Here I just inserted an excursus on the CJU jurisprudence. We have talked about it yesterday. I don't want to go into detail. It's, of course, a different perspective. It's an infringement procedure. And this is how the Luxembourg court assesses the Hungarian situation. Just for comprehensiveness or comparison, it's for the different approach the courts must have due to their capacity. Okay, let's move to Spain. And here I have again more detailed facts of the case to describe the situation at the border from the Spanish enclaves. So Melilla and Ceuta, I think you all aware of the situation there, the Spanish enclaves in North Africa, Algeria, and Spain has erected a very heavy fence installation there. Actually, there are two fence lines, high fences with barbed wire on top, and gates where you can have access to the territory of the enclaves from the Algerian side. So here the two applicants were living in Tanger in Morocco without legal status. On September 2016, they, together with approximately 150 other people, attempt to storm the border fence at Ceuta. So far the case has only concerned Melilla. I think this was the first case concerning Ceuta. To enter the Spanish territory. The one applicant managed to pass the outer fence and remained in the inner fence for 9 hours because he was brought down by Guardia Civil, injured by razor blade devices on the fence, and he was escorted back to American territory through gates. The other applicant entered the outer fence, climbed down again because he was injured and was brought to American territory by American gendarmerie, where he was beaten after an escape attempt. Both applicants did not receive medical aid before being handed over to Morocco, but later in Morocco. So here, this is an interesting aspect. I already described the general or the landmark jurisprudence in ND and NT concerning the situation in Melilla, the culpable conduct exception case. So there the court already has assessed the situation in general. So these are kind of follow-up judgments to say. So the decision was from July last year. There was no violation of Article 3, Article 4, Protocol 4, and Article 13. No violation. The similar background, as I mentioned, like in ND and NT from 2020. The assessment against Article 3 recalled the principle in the context of expulsion and the expelling state's duty in this respect, the provision of appropriate evidence on allegations of ill treatment, but no violation of Article 3 by a direct action of the authorities, of the officers, on the part of the defendant state Spain. The applicants injured themselves on the fence. That's how the court saw it. And finally, medical assistance, medical help was provided by the Red Cross in Morocco. So no violation of Article 3. Then the ND&T exception. The applicants did not make use of the existing procedures to cross the border, the official, the legal ways. And so no violation of Article 3 and no violation of Article 4, Protocol 4, prohibition of collective expulsion, because the applicants placed themselves in jeopardy to their own actions by participating in the storming of the border, taking advantage of the group's large number, did not make use of existing legal procedure for lawful entry, and this caused the lack of an individual removal decision. So, application of ND and NT jurisprudence. In general, what is new? And that's why I mentioned it in the facts, the question of the medical treatment. As I said, the court established that it's on the own culpable conduct of the applicants, that they did not use the official ways. But the court made a distinction between a violation by a direct action of the part of the dependent state, the Guardia Civil, and, for example, on the provision of an access to medical assistance and its obligation to protect persons under its jurisdiction by provision of means for legal entry. So there is an additional point, I would say, in this decision. So, okay, let's turn on to North Macedonia. Here we have the situation, again, a little bit more in detail. I will not read it out, but in detail we all know the so-called March of Hope in summer 16, March 16, here the case was, where a lot of people were crossing on the Balkan route, and they had to cross the border between Greece and Macedonia, North Macedonia. Actually, at that time it was Macedonia. Yeah, so this is the situation, and the people entered North Macedonian territory and were collected by army personnel and were turned back to the fence, and they had to cross the fence through a kind of gate or hole in the fence, and they were forced to go back to Greece. This is the situation more or less about in AA and others versus Macedonia. Interestingly, and that's, I won't read out this too, but the court very precisely described the whole situation in North Macedonia and the legal ways how you can enter North Macedonia at that time, including the number of persons entering at that time through which point of entry, because the main point of entry was Idomeni, which is at the Greek North Macedonian border, directly land border. So the court described this very detailed, and then came to the conclusion, again established that this was an expulsion, however it is called, or however it is called by the defendant state. It is an expulsion. Again, the ND and NT exception. The lack of an individual removal decision was justified by the applicant's own conduct, the question. So here, they circumvened the effective procedure for legal entry, and there's nothing in the case filed to suggest that potential asylum seekers were in any way prevented from approaching the legitimate border crossing points and lodging an asylum claim, or that the applicants attempt to claim asylum at the border and were returned. And it was the applicants who placed themselves in jeopardy. I wonder a little bit about this case, because when I remember the pictures at Idomeni at that time, and you say that they were able to approach the border and to go through legal procedures, to say, I doubt. But however, this is the court, how the Strasbourg court has assessed it. So what are the new elements? The same line like ND and T. But the cogent reason exception, but here the court is not persuaded that the applicant had the required cogent reasons, so here it's clearly it's required, it's a requirement to have cogent reasons for not using the border crossing points to cross in a legal way. So, briefly, some last cases from May 2020, MA and others versus Latvia. Like Poland, Latvia has the border to Belarus, and we all know that there at some stage was the policy, if it is not remaining, the policy to push refugees towards Europe. So Latvia is in the same situation. In a way like Poland. So the court made a reference to MK and others versus Poland. I have mentioned this before. And another landmark case, MA and others versus Lithuania, on the requirement to provide evidence for an application for international protection. And in this case, it was not provided by the applicant, so there was no violation of Articles 3 and 13. So this change of burden of proof thing, MK, and others versus Poland. And finally, a case, JNA and others versus Italy, a judgment of March this year. And here again, it's the situation in the Mediterranean, a Tunisian sea migrant detained in a hotspot center for 10 days in poor material conditions. And here the court established a violation of Article 3 in its substantive limb by inhuman and degrading treatment, violation of Article 5, because of arbitrary deprivation of liberty, and detention without clear and accessible legal basis, no reasoned decision. The legal reasons for the detention were missing, and the inability to challenge the de facto detention. And a violation of Article 4, Protocol 4, the prohibition of collective expulsion, the removal to Tunisia without proper regard to applicants' individual situations when issuing a refusal of entry and removal order. So, at the time, I think my time is over. So here I suggest some points for discussion. I'm open for any other questions, remarks, or points for discussion. Thank you very much.